welcome to the deep dive. Today we're really getting into something foundational, the 14th Amendment to the U.S. Constitution.
Yeah, it's one of those post-Civil War amendments, the Reconstruction amendments, and honestly, it's shaped so much.
Absolutely. And we're going to look at it through a couple of, well, interesting sources today.
That's right. We've got some excerpts from a pretty recent executive order, 14160 from January 2025. And we're also drawing on the Wikipedia page on the 14th Amendment itself, which gives a great overview.
So our mission here, for you listening, is to get a really solid but, manageable understanding of this amendment. What are the key parts? Why did they come about back then? And crucially, why are we still talking about them? Especially with things like that executive order popping up.
Exactly. It's all about context and relevance. Okay, so where do we start?
Let's set the scene. The 14th Amendment wasn't just dreamt up, right? It came right after the Civil War.
Right. Adopted July 9th, 1868, it was a direct response to the massive questions about the status of, millions of newly freed slaves,
Right.
and getting it ratified wasn't easy. The former Confederate states, they pushed back hard.
And even today, it's Section 1 that gets most of the attention, doesn't it?
Oh, absolutely. Our sources highlight that it's the single most litigated part, not just of the amendment, but of the entire Constitution.
Wow. Think about that. More legal battles over those words than any others.
Yeah, and it kicks off with the Citizenship Clause that says, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside.
Okay, seems clear enough now, maybe. But back then,
Yeah.
revolutionary stuff.
Totally. Because it directly overturned the Supreme Court's Dred Scott decision from 1857.
The one that said people of African descent couldn't be citizens. Chilling.
Exactly. And this clause basically put the core idea of the Civil Rights Act of 1866 into the Constitution itself. That act had already granted citizenship to people born here, except, interestingly, children of foreign diplomats.
So it established birthright citizenship, what we call just solely, right?
Yeah.
Citizenship by soil.
Precisely, which is different from many European countries that use just sanguineous citizenship through bloodline, through parents. And, during the debates in Congress, they specifically rejected attempts to exclude certain groups, like based on anti-Romani prejudice. They wanted it broad.
And the courts have mostly stuck to that broad idea.
Largely, yes. The big case is United States v. Wong Kim Ark from 1898.
Yeah.
That confirmed that even children born in the U.S. to parents who weren't citizens are citizens under the amendment, a landmark.
Okay, Wong Kim Ark. Got it.
Uh,
But it wasn't instantly applied to everyone born within U.S. borders. What about Native Americans?
That's a really important complexity. The 1884 case, Elk v. Wilkins, initially said Native Americans born into tribes weren't automatically citizens. The reasoning was that tribes were seen as separate nations, so those individuals weren't fully subject to the jurisdiction of the U.S. in the same way.
Subject to the jurisdiction thereof. That phrase carries a lot of weight. So how did that change?
It took specific laws. First, the Dawes Act in 1887 offered citizenship under certain conditions linked to, assimilation policies like land ownership. But then the Indian Citizenship Act of 1924 finally made it clear. All Native Americans born within the U.S. are citizens, period.
Okay. The sources also mentioned losing citizenship. Renunciation. Is that easy to do or for the government to force?
It used to be easier for the government to strip citizenship. Cases like Mackenzie v. Hare, where a woman lost citizenship for marrying a foreigner, or Perez v. Brownell upheld involuntary loss. But the Supreme Court really washed that back later. Cases like Afrim v. Rusk and Vance v. Terrazas established that basically you have to want to give up your citizenship. It requires a clear, voluntary act of renunciation. The government can't just take it away for things like voting in another country's election anymore.
Which brings us right up to date, or almost, with that Executive Order 14160 from January 2025.
Right. That order tried to carve out an exception to birthright citizenship. It aimed to deny citizenship to U.S.-born children if their parents had illegal or temporary immigration status.
But the sources say that wasn't really what the amendment's drafters had in mind.
Exactly. The historical record suggests the 39th Congress didn't consider that kind of limitation. And legally, it hit a wall. Federal judges have blocked it, calling it unconstitutional. It really shows how strongly that birthright principle from Wong Kim Ark is embedded.
So the courts reinforced the traditional understanding.
Okay.
That covers citizenship pretty well. What's next in Section 1?
Next up is the Privileges or Immunities Clause.
Right. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. Sounds important.
It sounds huge. And the idea was partly to connect it back to Article 4 of the Constitution, which talks about privileges and immunities between states. An early case, Corfield v. Coriell, even listed some examples like the right to travel, habeas corpus, basic stuff you'd expect.
But there's always a but in constitutional law, isn't there?
Chuckles. Often, yes. The big but here came with the slaughterhouse cases in 1873. The Supreme Court interpreted this clause very, very narrowly. They said it only protected a limited set of rights related to national citizenship, not the broader rights people held under state law.
So things like traveling overseas or petitioning the federal government.
Exactly. And crucially, the court decided not to use this clause to make the Bill of Rights apply to the states.
That seems like, well, a major fork in the road. It could have gone very differently.
Many scholars think so. And interestingly, Justice Clarence Thomas, much more recently, has argued we should revisit that. He thinks the Privileges or Immunities Clause was meant to apply the Bill of Rights to the states. He mentioned it in cases like McDonald and Timms.
But that's still a minority view on the court today.
It is, yeah. The main vehicle for applying the Bill of Rights to the states became something else.
Okay, let's move to that something else then, the Due Process Clause. This one feels like it comes up constantly.
It really does. The clause reads, "Nor shall any state deprive any person of life, liberty, or property without due process of law."
So basically taking the Fifth Amendment's due process requirement, which applied to the feds, and making it apply to the states too.
Precisely. And courts break due process down into two types, generally. There's procedural due process, or the government's procedures fair when they act against you, like notice, a hearing, that sort of thing. And then there's substantive due process. This one's trickier. It asks if the government has a good enough reason to take away your life, liberty, or property in the first place. Does the law itself go too far?
And that's where those levels of scrutiny come in, right? Rational basis versus strict scrutiny.
Exactly. Most laws just need a rational basis, some logical connection to a legitimate government goal. But if a law touches on a fundamental right, the government has to meet strict scrutiny, a much higher bar. The law has to be narrowly tailored to achieve a compelling government interest.
Substantive due process. That sounds like it could give courts a lot of power. Has it always been used the same way?
No, its history is, well, quite a ride. There was the Lochner era, roughly the early 20th century. Back then, the court used substantive due process, specifically a freedom of contract idea, to strike down lots of economic regulations, minimum wage laws, maximum hour laws.
Like Lochner v. New York itself, the baker's hours case.
That's the most famous example, also Allgaier v. Louisiana.
Yeah,
But that era eventually ended. The court backed away from heavily scrutinizing economic laws around the time of West Coast Hotel Co. v. Parrish.
But substantive due process didn't vanish. You said it was still important for other rights.
Absolutely. It became the foundation for recognizing rights related to education and, maybe most famously, privacy. Cases like Meyer v. Nebraska and Pierce v. Society of Sisters protected parents' rights in education. And then the right to privacy, which really gained steam with Griswold v. Connecticut.
About contraception.
Right. And that privacy right was then the basis for Lawrence v. Texas striking down laws against same-sex intimacy and Obergefell v. Hodges establishing marriage equality.
And Roe v. Wade initially.
Yes, Roe also relied on that substantive due process right to privacy for abortion access.
But that was overturned by Dobbs v. Jackson Women's Health.
Correct. The Dobbs court explicitly rejected the Roe reasoning, stating that abortion wasn't, in their view, a right deeply rooted in the nation's history and tradition, which is part of the substantive due process test. A huge shift.
So, substantive due process is still debated. But the Due Process Clause also did something else huge in corporation?
Yes, the incorporation doctrine. This is how most of the protections in the Bill of Rights Amendments 1 through 8 really got applied to state governments.
Because originally the Bill of Rights only restricted the federal government.
Exactly. Barron v. Baltimore in 1833 confirmed that. States could, theoretically, violate those rights without violating the U.S. Constitution.
Until the 14th Amendment.
Right. Starting with a case called Chicago, Burlington, and Quincy Railroad in 1897, the Supreme Court began saying that some Bill of Rights protections are so fundamental to liberty that the 14th Amendment's Due Process Clause prevents states from violating them.
So they incorporated them one by one through the Due Process Clause, even though, as you mentioned, some think the Privileges or Immunities Clause was the intended way.
Correct. Akil Reed Amar is a prominent scholar who makes that argument. But historically, due process became the vehicle.
Have all the rights been incorporated?
Almost all the major ones. The sources note a few exceptions. The Fifth Amendment's requirement of a grand jury indictment for serious crimes hasn't been fully incorporated. Neither has the Seventh Amendment's right to a jury trial in civil cases. And the Third Amendment about quartering soldiers, well, it just hasn't really come up in a way the Supreme Court needed to address regarding incorporation.
Fascinating. Okay, that leaves one major clause in Section 1, equal protection.
The Equal Protection Clause, nor deny to any person within its jurisdiction the equal protection of the laws. This is arguably the heart of the amendment's promise of equality.
And its purpose was very specific at the time, wasn't it?
Absolutely. It was aimed squarely at the black codes being passed in the South after the war laws designed to restrict the rights of newly freed black people. It constitutionalized the anti-discrimination ideas from the Civil Rights Act of 1866.
And early cases started to flesh that out.
Yes. Strouder v. West Virginia said states couldn't exclude black men from juries just based on race. And Yickwo v. Hopkins was huge. It said even a seemingly neutral law, if applied in a discriminatory way, violates equal protection. That case involved Chinese laundry owners in San Francisco.
And notice the wording. Any person within its jurisdiction,
Yeah.
not just citizens.
Crucial point. The Plyler v. Doe case confirmed this applies to undocumented immigrants, too, at least regarding access to public K-12 education. The court cited Wong Wing v. United States from way back in 1896 on that.
And this idea of equal protection also applies to the federal government, even though the clause only mentions states.
Yes, through something called reverse incorporation. The Supreme Court found in Bowling v. Sharp, the companion case to Brown v. Board dealing with D.C. schools, that the Fifth Amendment's Due Process Clause contains an implicit equal protection component that binds the federal government.
So federal and state governments both have to provide equal protection. What else has it been applied to? Taxes.
Yep, it's come up in taxation cases, like Metropolitan Life Insurance Cup v. Ward. It also intersects with the Dormant Commerce Clause sometimes. And then there's the whole complex issue of corporate personhood, the idea that corporations count as persons under this clause, giving them certain constitutional protections. That started way back with cases like Santa Clara County v. Southern Pacific Railroad.
Okay, but the most famous application, or misapplication initially, was segregation. Plessy v. Ferguson.
Plessy in 1896 is infamous. The court upheld separate but equal facilities, effectively sanctioning decades of Jim Crow laws. A terrible stain. They even extended it in Berea College v. Kentucky, allowing states to forbid private colleges from integrating. It shows how deeply segregationist thinking ran.
Until Brown v. Board of Education.
Brown in 1954, a unanimous court finally declared that in public education, separate facilities are inherently unequal, striking down Plessy. Monumental.
But overturning the law didn't instantly change reality, did it?
Not at all. There was massive resistance. It took years of further litigation, federal intervention, things like busing orders, to even begin desegregating schools. And debates continue today about race-conscious policies in schools, as seen in cases like Parents Involved.
And equal protection isn't just about race, right?
Definitely not. Hernandez v. Texas made clear it protects other ethnic groups, like Mexican Americans. And it's been critical for gender equality. Think United States v. Virginia, opening VMI to women, or Levy v. Louisiana, protecting rights of children born outside marriage.
This is where those different levels of scrutiny really matter, like intermediate scrutiny for gender.
Exactly. The court uses intermediate scrutiny for sex-based classifications, tougher than rational basis, but not as demanding as strict scrutiny for race. Established in cases like Craig v. Boren, Reed v. Reed was an earlier key gender case, too.
Okay, and then there's affirmative action. That's been a whole saga.
Oh, yeah. A long series of cases trying to figure out when, if ever, race can be used as a factor to promote diversity, especially in higher education. From Bach in '78 through Gratz and Grutter in 2003, Fisher, Schwett, and then the very recent Students for Fair Admissions v. Harvard decision, which significantly curtailed race-conscious admissions.
It's clearly an area where the meaning of equal protection is fiercely contested.
Without a doubt. And the clause has also reshaped voting rights.
One person, one vote.
That comes from cases like Westbury v. Sanders and Reynolds v. Sims, applying equal protection to legislative districts. It's also the basis for challenging racial gerrymandering, Shaw v. Reno, though the court declared partisan gerrymandering claims non-justiciable in Rucho v. Common Cause.
It even played a role in Bush v. Gore.
Yes, the unequal standards for recounting votes argument in that case invoked the Equal Protection Clause.
One last thing from Section 1 in the sources. The state actor doctrine. What's that about?
It basically asks, when does the 14th Amendment apply? Since it restricts state actions, the doctrine helps define when something done by a private party is still considered state action. For example, Shelley v. Kramer found state action when courts enforced racially restrictive private agreements. But later cases like Jackson, Utility Company, and Flag Bros, warehouse lien, narrowed when private action counts as state action. It's about drawing that line.
Okay, wow. Section 1 is incredibly dense. What about the other sections? Briefly.
Sure, Section 2 deals with how seats in the House are apportioned among states. It got rid of the old three-fifths compromise and also included language about potentially reducing representation if states denied voting rights to adult men, though that part wasn't really enforced effectively. Section 3 is the disqualification clause barring people who engaged in insurrection after taking an oath to the Constitution from holding office. It's gotten renewed attention recently.
Understandably. And Section 4.
Section 4 confirms the validity of the U.S. public debt, but invalidates any Confederate debt or claims for compensation for freed slaves, basically settling financial scores from the war.
And finally, Section 5 gives Congress power.
Yes, Section 5 is the enforcement clause. The Congress shall have power to enforce, by appropriate legislation, the provisions of this article. This is the constitutional hook for many federal civil rights laws. Even the slaughterhouse cases, while limiting Section 1, acknowledge this power.
But there have been limits placed on that power, too.
Right. The civil rights cases in 1883 said Section 5 didn't let Congress regulate purely private discrimination, though Congress later found ways around that using its Commerce Clause power, like in the Heart of Atlanta motel case upholding the Civil Rights Act of 1964, and later cases like Katzenbach v. Morgan upholding part of the Voting Rights Act, and City of Bourne v. Flores, striking down the Religious Freedom Restoration Act as applied to states, have debated how broad Congress's Section 5 power really is. Is it just remedial, or can Congress define the scope of rights? That's the tension.
It's just amazing to think about the context when this was all being debated and ratified, right after the Civil War.
Absolutely. It was proposed because the Civil Rights Act of 1866, meant to protect freedmen, had been vetoed by President Andrew Johnson, though Congress overrode the veto. They needed something stronger, something constitutional. Key figures like John Bingham were central to drafting it. But even then, some radical Republicans felt it didn't go far enough, leading eventually to the 15th Amendment focused on voting rights.
And getting the states to ratify.
Oh, that was a struggle. Many southern states rejected it initially. It took the Reconstruction Acts, basically making ratification a condition for readmission to Congress, to push it through. There was even controversy over states trying to rescind their ratification after the fact. It was messy, eventually certified in July 1868.
And some states ratified it much later, formally.
Yeah, Delaware, Maryland, Kentucky, they came around years, even decades later. Shows its enduring symbolic importance, I suppose.
Was there ever a serious attempt to change it later?
There was one notable proposal mentioned in the sources by Senator Borah in 1937. It was a reaction to FDR's court-packing plan and the Lochner-era decisions. Borah wanted to significantly change the due process clause, basically.
But it didn't get far.
No, partly because the Supreme Court itself started shifting its interpretation of economic regulations, the famous switch in time that saved nine, which kind of took the wind out of the sails for a major constitutional revision like that.
So wrapping this all up, the 14th Amendment is just massive. It redefined citizenship, promised equal protection, guaranteed due process from the states.
It's the bedrock for so much modern civil rights law. Its journey through the courts, the interpretations and reinterpretations, it tells a huge part of the American story after the Civil War.
And for you listening, hoping for those aha moments, you can see how this single amendment, passed over 150 years ago, keeps generating debate and shaping everything from who is a citizen to voting rights to privacy.
Exactly. It connects directly to so many issues we grapple with today. Its language seems simple, but its application is endlessly complex.
Which leads to a final thought for you to chew on. Think about those fierce debates during Reconstruction about equality, citizenship, federal power versus state power. How are those same fundamental questions still playing out today in discussions around the 14th Amendment?
Yeah, what parts of its interpretation seem most alive, most contested right now in our own time? Something to consider.
That's all the time we have for this deep dive. Thanks for joining us.